Hello everyone, King here. Welcome to my channel. If this is the first time coming to my channel, if not, for others that saw my other video, my first video, welcome back to my channel, Fourth King Media. In this video, I'll continue on with my explanation, explaining my experiences, how I first got involved in heir property issues. I did say there's going to be a second part video, but the video you're seeing is actually a continuation of the first part one. So, just not to add confusion, that this video you're seeing is not part two, it is a continuation of part one, giving further explanation to my experiences as to what I learned and what I discovered, and do my research and reviewing court documents, trying to get a better understanding of all the legal issues dealing with the heir property in regards to my family. So again, this video that you will be seeing is a continuation of part one, giving further information, having further conversation discussions about my experiences and how I first got involved in dealing with the heir property issues. So without further ado, let's get into the video. Thanks for watching and enjoy.
Okay, hello everyone. King back for another video. Actually, in this video, it's going to be a two-part video, part two video, excuse me, for my previous video where I talked about why I got involved in the heir property issue, for us to quiet the title and try to resolve the question as to who are heirs and who is not heirs, as well as part owners of this heir estate. Reason being for this part two, I have left out some information. I think it's vital information, key information. Of course, I didn't do this intentionally. Just going back through the video, and I left out some key points that I think is essential to my story. And when I say story, I don't mean a tall tale or a fib or a lie, but my experience involving this issue, trying to resolve, the legal side of the house, as well as dealing with family side of the house. So this is a part two to that video. So if you have not seen that video, please go watch that video. I'll leave a link in the description below, or put a shortcut to that video now or at the tail end of this video. Anyways, so if I may go back to the period of time where I was in a transition period of retiring from the Air Force and becoming a citizen, a civilian again. So if you recall that, I had my promotion ceremony on June 3rd of 2006. June 4th, I was wheels up to basically enjoy my retirement by way of vacation, taking a long holiday, nearly 2.5 months. And during the period of time, so from June until I returned, or even into like September, October of that same year, 2016, there was a series of meetings that were called to discuss how all parties that are involved in that lawsuit were going to resolve their issues and work together and move forward. Now, understanding there's already disagreements, there was hurt feelings and animosity, and that carried over from that lawsuit. Again, because that lawsuit was about the money being spent versus resolving the heir property issue, dealing with all the heir property issues, and the main one being who are the heirs, owners of the property, now that it's been over 100 years since the original owners have died and passed away, and leaving no will to identify who will inherit their share of the property, and who their heirs are, right? Who their children are, who their spouses, all that stuff. Some of it was identified, some of it was unidentified. So basically, this heir property was passed down through oral history, right? Family oral history, and those that were living within the area, and were told that they were heirs, owners of this property, and so forth and so forth. So, looking at my records, there was, see, one, two, three. At least three sets of meetings that were called between June of 2016 and I want to say September of 2016, maybe even further past that, maybe even into October, November timeframe. And I have the minutes from those meetings that were called. Now, granted, again, I was on vacation, so I was not in the country. I was not in the state of South Carolina when these meetings are going down. But leading up to filing a lawsuit, hiring a lawyer, and filing a lawsuit, or the civil action to acquire the title, I was given these documents, given these meeting minutes by members of my family. Most of them were probably present, others were not present. So again, there was lack of cooperation. Not everybody was on board. Not everybody was willing to cooperate. Not everyone was willing to listen and do the right thing, right? But these meeting minutes, basically show what was discussed during the meetings, what was said. And that's the point of having meetings, right? To record what was stated. If there were any, pertinent conversations, any pertinent decisions that were made, who said what, what was the verdict, what was the decision, what action is required. And it identifies who was present, who was not present. And it's a small group of people. It wasn't a large majority of, those that had a vested interest in the property. So that's part reason why I got involved, because not everybody was included. My grandmother was not notified of these meetings, and my grandfather's living brothers and sisters, my mother to be exact, and her siblings, and a whole slew of people that should have been notified, for one, that these meetings were ongoing, and they were not. So basically, what I'm saying is that there were everybody was not being included into the conversation, into the meetings. So you have to be inclusive, can't be exclusive. So you can't pick and choose as to who's going to be part of this meeting, part of this conversation. We went to court, filing a lawsuit against members of my family and others for their alleged crimes, for their alleged infractions in regards to the money. Saying that they had no right spending that money, had no right doing this. Well, when there's meetings being called and people are not being notified, for one, of these meetings, and people that are attending these meetings, it's questionable as to whether or not they should be there. Questionable whether or not they are part of this estate, legally part of the estate, or they are part of the heir property by, either because their grandparents or great-grandparents or whoever was on the original deed. And so through oral history, they have an invested interest in the property, right? They claim to have interest in the property, yet, but they will not prove it. So that's part of the reason why it's necessary to have a quiet title action, as well as to have a will to say, here are my heirs. Here I'm leaving my share of ownership to. Upon my passing, I'm gonna leave this to this person, my assets to this individual who is either my son, daughter, spouse, whoever. So again, there was call to action, right? And not everybody received that call to action. Not everybody received the call to action to come and be a part of these meetings to move forward, right? This is nearly, how many months after the first lawsuit concluded in October 2015, and still they had no resolution. There was still no resolution. There was no verdict on who owned the bank account, and there was no verdict on who are their heirs, owners of the property, and who should be managing the property, who has rights to the property, so forth, so forth. Again, so that's part reason why we have the quiet title action, is to update the title, declare a title, update the deed, right, based on evidence, information, based on, you know, the current situation. So again, there's documentation in here. And you know, again, I was not in the country when I was having these meetings. One of my uncles and cousins went to the meeting and actually recorded one of the meetings. And in the meeting, again, there's a call to action. It was discussed that everybody had to prove who they were and how they can be heirs to the property. Again, you know, there was disagreements. There was things said as to why this or why that, why I need to prove this, and you know, so forth and so forth. Right? Again, lack of cooperation, lack of understanding, lack of willing to do the right thing. You know, you can't claim. I say you can't, but you know, it can't be a claim to have ownership and property, be part of this property, and not be legally obligated to prove who you are. Right? Just no different if, you know, anybody goes out and buy a vehicle or a home, you got to prove that you purchased that home, that you have the rights to purchase that home and live in that home, and that anybody outside of that home that doesn't belong there can't just come and set up shop in your home or your backyard or on your land if you own it. At that point, they're trespassing. They're squatting on your land. It's the exact same thing. Everybody at this point that was living on the property was squatting on the property, even though they may have true ownership to the property, part ownership to the property, but based on their family history, but it was not proven in court. There was no deed with their names on it. There was no deeds with anybody's name on it saying that they're part heir owner to this property. So again, point to quiet title. It was necessary. It was necessary. And I want to point out that, you know, prior to following this in court, you know, there was a law firm based out of Columbia that actually provided legal guidance, legal direction to what needed to be done, as far as what needed to be done with the property. And actually, I don't have that right now in front of me, but it explains, in this letter explains what was the purpose of quiet title. The law firm gave legal guidance and direction as to what needs to be done. You know, there's a slew of things like doing a survey their land, update the survey, identify who's all on the property, you know, basically do extensive research on the family tree, provide that, you know, follow the civil action to quiet a title. And all this was put in a letter, drafted in a letter. Again, I was not part of that lawsuit, but the law firm did a title extract on the property and came up and discovered all these legal discrepancies, or discrepancies with the title. We also showed that there was fraud committed, fraud and forgery committed in regards to who owned the property. So again, part of the reason why I got involved, you know, because there was a need to do this, and even though not everybody was on board, those that have the greater share or greatest interest in the property have legal precedence, have the right to do it. And I'm going to read the explanation on quieting a title. Right? This is a law firm. If you can see on my screen, I'm doing screen capture now. It's from the Watts Law Firm. I believe it's here in South Carolina. Yeah, Summerville, South Carolina. So some of this information is taken from the other prestigious law firms in the country, but question is here, why on the website, why would I need to file a quiet title action in South Carolina? You can read along with me. Clearly, if you believe that you own a piece of property, you will want to eliminate any claims that someone else might have your land. Therefore, you will file a quiet title action and have a hearing before the master of equity to determine ownership of the property. When you file a quiet title action, you are essentially telling anyone with a claim to a property that you intend to eliminate their claims, and that if they want to defend those claims, they need to attend the hearing and present their argument. Essentially, that's what we did, right? There was a call to action in that meeting. You know, one of the meetings where, you know, a person stood up and said everybody must prove that they're heirs of property, and not only then, but during the 5-year span or 6-year span from 2011 to 2015, it was mentioned as to who were heirs and who was not heirs. People gave testimony, gave on record during depositions, during court hearings when they're being questioned on the stand as to who they were, what was their involvement, what was their connection to the heir property. So the question was there. Again, it's right here. It's quite a title. You know, and so again, I was a plaintiff in the case along with members of my family who had, right, they were being sued for that $20,000, that money being spent, you know, and there was question as to who were heirs, rightful owners of this property. So they had every right to file this lawsuit in court, regardless of what everybody's feeling thinks, because their rights were being trampled on. Right? They basically were not having a say, a fair say as to what can be done on the property. Their rights were being excluded, not being included. And there's a whole lot of people that, you know, again, on my grandmother's side and my grandfather's side, that were not being informed, were not being included, were not having a say as to who should be managing the property, who should be living on the property, how the property should be used, all that stuff. Again, so it's all right here on this page, this website from the Watts law firm out of Somerville, South Carolina. You know, and it talks about here that the defendants in a quiet title case can either be known or unknown. Known parties are individuals or entities that have a claim or interest or possession of the property. The claimant or claimants are unknown. However, simply publishing notice of the lawsuit in legal paper is sufficient to move forward with legal action. And it talks about, again, the actions uncontested, you are able to obtain quit claim deed. That was not our intent. Our intent was to basically acquire the title and identify who are the heirs owners of property. So everybody who had a vested interest in the property, you know, had the right to come to court to be part of it. Again, there was call to action, you know, and prior to actually following this civil action in court, the courts, you know, I advised my mother to draft a letter to her family on both sides, you know, her father's side, her mother's side, and again, call to action. She drafted a letter. Her version of the letter was changed, and it was mailed out by members of her family as a call to action from us to them, or from her family to them, to everybody else. That's within her family tree, on her father's side or her mother's side. And this was in 2016. And then when I got involved in February, March, April 2017, I sent out letters, over 40 letters. Again, call to action, notifying people, members of the family, what was going on, giving them opportunity, as I said here, you know, to come forward. If they have a claim, if they have an interest in the property, to be part of it, they have the right to come there and make their argument, and not everybody want to get involved. That everybody want to be involved, because either, you know, I could be wrong on this, either it's my assessment, my opinion, that didn't have the money to pay for lawyers, or didn't understand the complexity of the situation or to understand what's the need, or just downright didn't want to get involved because they didn't want to ruffle anybody's feathers or didn't want to, let bygones be bygones, which is fine, but not when other people's rights are being trampled. If this was being fair across the board, yeah, there probably will be no need, but at some point it needed to be done. And the courts advised those parties that were part of the lawsuit, again from 2011 to 2015, whether they're plaintiffs or they're defendants, the judges and lawyers that were involved in that case that either was pursuing the case, defending the case, or overhearing the case as a judge, gave their legal guidance and direction as to what needed to be done. Hey, you all need to quiet the title. This needs to be determined. I can't make a ruling on this, this, and this, and this, and this. Again, the information was there, and people chose to ignore it. So it's all here. It's all here as to what the quiet title means and how to accomplish it, what needs to be done. Regardless of what people think and say and feel, members of my family, had a right to bring it before the court to quiet the title because their rights, right, will be trampled on. They were not allowed to be part of this, and they did not agree with all things being done. So, and I had the means to do so. I had the means to pay for a lawyer, just like I had the means to write that $3,900 check to help pay the taxes. And you got people living on the land that were not contributing to said taxes. We're not, you got over 30-some trailers or homes on the property, and nobody's coming out of pocket to help pay the taxes. So tell me how that's right, how that's fair, when individuals who don't live on property, such as my grandmother and my grandfather when he was alive, and their siblings, their nieces and nephews, grandnieces and nephews, grandchildren, don't live on those land, but yet they're not being allowed to be included into the conversation or to attend meetings as to what needs to be done. No one's sharing information. Everyone's holding on to their piece of the pie. Again, I could be wrong on this. I could be wrong, but the information is there. The evidence is there. The conversations were, whether it was during a deposition, court transcripts, court hearings. Now I could transition to, again, still talking about my involvement, my experience leading up to the lawsuit, to hiring a lawyer and filing a lawsuit. So things that happened and what I discovered. So essentially, I kind of covered a little bit about what's a quiet title action. But again, looking at this law firm, the other link on the webpage, the same law firm that's based out of Somerville, Watts Law Firm, PA. So what is a quiet title action in South Carolina? Again, here it is: a special legal proceeding to determine ownership of real property. A party with claim ownership to the land can file an action to quiet a title, which serves as a sort of lawsuit against anyone and everyone else who has claim to the land. If the owner prevails in the land and quiet title action, no further challenges to the title can be brought. So, again, there was call to action. And again, me recommending to my mother to write this letter to contact her family, right, was the first call to action, actually from the family, that is, to family members. I don't know what responses, what kind of responses came from that, but when I hired a lawyer, and the lawyer is advising me and my family as to what needs to be done, what the law requires of us, I took the lead and wrote the letter. Again, over 40 letters were mailed out to address the issue. These letters were mailed out to my grandfather's side and my grandmother's side of the family. Identified who I was. That I was a son of my mother, which is their cousin or their niece or aunt in some cases. So, and then, I got responses. Again, let's fast forward. I mean, I might be jumping back and forth, but let's fast forward to 2017. Now, this is prior to the lawsuit being filed. Again, I'm sitting here meeting with my lawyer, being advised of what needs to be done and how to make things happen to ensure that everybody's getting a say in this, because it's required by law. It's the right thing to do. So I drafted a letter. Again, I mentioned before, only two individuals contacted me. Two of my cousins contacted me in the early part of 2017. Right? I was contacted via email, my personal email, asking, I think it was like 9 or 10 questions. I answered those 9 or 10 questions, and I informed my cousin that if they have any more questions, call me that evening between 5 p.m. and 6 p.m. Sure enough, we had a conversation, and I explained my stance, explained my involvement, explained what's going on. And so, you got any questions or comments? You don't agree with this, you can go talk to my aunt, my mother's sister. And that was the last time I talked to that cousin in particular. And then another cousin called me either that week, that day or that week, or further down the road, asking the same thing. And I gave them the same answers. And I'm going to say both these cousins sent me documentation via email, showcasing their involvement. They try to resolve these issues at some point in their lifespan since the 1990s. And one cousin sent me copies of letters that was drafted to the individuals who were supposed to be part of the management team, management board, committee, whatever you call officers. Again, this is prior to the first lawsuit, so between 2006 2010. My cousin expressed their concern about how the property is being managed, how things are being done. So, I wasn't the first one to try to resolve these issues. That's going on. But again, this is my experience. Right, wrong, and indifferent. Call it hearsay. Call it, tall tale. Now let's back up to after meeting with the lawyer and hiring a lawyer in November 2016. Again, this is, I returned home, retired from the Air Force, after seeing information about the meetings that were being held, seeing the video of the meeting for the call to action to come forward and provide information as to who you are and how you came to be heir to property. Those that were in the meeting, that per se. So you sit down with the lawyer advised us, here's what the law states, here's what's required, here's what y'all need to do. So we had to build our family tree. How are we going to do that? Through research, right? Through research, understanding our oral history, and members of my family already had the information. All you have to do is put it on paper to make it understandable. So basically, what happened is that members of my family called around to cousins, aunts, uncles, on again grandfather's side and grandmother's side. But in their case, on their father's side, on their mother's side, everybody they knew, they called and got addresses and names and phone numbers and date of births and date of deaths, and to build out this family tree. Again, nobody contacted me nobody contacted me because at the time they didn't know that we were doing this. They may have heard it from members of the family that contacted them, but they didn't hear it from me. So I basically took that information, me and members of my family took that information and put the information on poster board. So we had four big trifolds poster board, white poster boards, to build out this family tree for both sides of the family. Again, on my grandfather's side and my grandmother's side. So going back to the original owners, right? My grandfather is the grandson of one of the original owners, and my grandmother is the great granddaughter of one of the original owners. So, my mother and her siblings and some of the cousins, have ownership on both sides of their parents. And I'm not trying to exclude others that have rights to, have rights to the property by way of their parents or grandparents, as it pertains to their family history, leading back to one of the original owners, like in my case, right, on my grandfather's side and my grandmother's side. So again, call to action, come forward. You got to provide evidence to who you are, right? If you have a claim to property, come forward. That's why we're going to quite a title. Again, it talks about real property ownership, right? It goes on his website here again from a Watts law firm based out of Somerville. Is a suit to quiet a title necessary? And basically it says in some cases yes. To remove that cloud of that question of as to who's heirs, who are not heirs, who are owners and who is not owners. Because again, if years down the road, again, it's been over 100 years, there's the risk of losing his land because someone fails to pay attention to what's going on, doesn't follow rules and follow the law, right? Whether there's no money to pay the taxes. Again, you got people living on the land and not contributing to the annual taxes, not working the fields, not farming, and not making the land work for itself to where there's money in the bank account to pay the taxes every year. I'm not saying there's anything wrong with that, but to avoid any kind of, to avoid that being an issue, to risking losing the land because people can't pay their taxes, and it happens all the time. This ain't the first time. This, our case is complex, but there's individuals that are heirs to a state, part owner to an estate of heir property here in South Carolina, in Louisiana, and Texas, and Mississippi, Alabama, who have lost their land because they failed to pay taxes, or because somebody who had rights to property sold their share to a land developer. So over time, that land developer, acquired land to have a greater share of the property, right? And then filed petition to partition and sell the property or acquire the title, which is all required by law when there's a question as to who heirs owners of property, because the original owners died without a will. It didn't go through probate. So we risk that, and that person who acquired that land through buying up people's shares of the property had that right, and no one can. I mean, you can contest it, but if it's uncontested, that person basically, illegally acquired the land, and everybody who lives on the land, they're out. They got to pack up and move. And that's why I got involved, is to protect this property, to remove that cloud hanging over this property as to who heirs and owners of property. Now, that can of worms was already opened up in the first lawsuit. It was already opened up. It was already put out there when they filed that, when it was filed in court to go after members of my family for the alleged crimes and spending that money. And the court says, well, who owns this bank account? Who were the rightful owners of the bank account and the lands? How was it that this money came about? Right? Was the money from use of the land through lease agreements, cutting timber, farming subsidies, whatever? That's the case. Who had that right to do that? Who had the right to conduct business on behalf of the heir property and put the money in the bank? So therefore, who has rights to use that money? Again, the cloud was over deed over the property. So one way to do it is to acquire the title. Acquire the title. So is it necessary? Yes. Regardless of what others may think, even if you have 100 people disagreeing, if you had 20 that said, you know, hey, we're not getting our fair share, we're being excluded, our rights are being trampled on, they have the right to go to court to update the title, to update the deed, declare a title, to remove that cloud from hanging over the property legally. So that's why I got involved, you know, to help my family do this. Whether people disagree, it don't matter. You know, really, in my opinion, and I say this as a, it might sound kind of contradictory, but opinions don't matter to the court unless you can back it up with facts, right? The opinions of the court matter based on law. And sometimes, you know, when it comes to family and law, there's that gray area. People's feelings are going to get hurt. People don't understand. Well, I don't understand this. That's messed up, man. We're family. Well, or that's not right. It may not seem right to you, but judges and lawyers, you know, judges are paid or in a position to make those hard decisions, just like leaders, right? Leaders, just like your parents. Parents, there is, you know, they're there to guide you and direct you and make that hard decision as to what you can and can't do. Even if you don't like it, you got to abide by the rules. When you're living under their household, when you go to court, that's a judge's house. You know, he or she is a parent. Again, that's just my opinion. That's my take on it. But another part on this website, again, this is for me doing my research, trying to understand the complexity of this case, this issue, acquire the title, because I had to learn this. I didn't wake up one morning and say, "Oh, I know everything. I'm gonna these legal terms like acquire title and lists, pendants, and all this stuff." I had to do my research. I learned as I went along, going through court documents, going through, you know, I have this book here. I have several binders of documents from previous court hearings, from the deed office, from doing my research. You know, documents my members of my family gave me, my cousins gave me, my aunts, uncles gave me. I have it all, and some of it I produced myself. Some of it I, you know, acquired and you know, archived it for safekeeping. Some of it's from my own lawyer. So again, try to do things right, trying to be transparent, open, honest, trying to find a solution to the problem. And the only way to do it is go to court, follow the cartel action, because there's individuals that, you know, committed fraud and forgery and engaged in activity they had no business being engaged in, living on the land, trespassing on the property, squatting on the property. So all that needs to be dealt with, because you got people living on the property, you know, between 2000 and 2010, moving trailers on the property. But who are these people? How came to be on living on our land? Who authorized that to come? Who authorized these individuals to come on land? Because again, and I discovered, but my family members already knew, but I was given this information, you know, through my involvement, initial involvement, that there were set of bylaws out there, and it mentions in the bylaws that for people to move onto the property, to use the land, to live on the land, it had to be majority rules vote. 12 people is not majority rules. The officers of the estate are not majority rules. So if you have 500 people who are part of this estate, but only 12 people are making decisions, how's that right? It doesn't matter, and I'm clear on this, it doesn't matter if 200 or 300 of these individuals live outside the state of South Carolina. They have a right to come down here and get involved and be informed as to what's going on the property. It doesn't matter if they never set foot on this property ever again in their life. It doesn't matter. They have rights by way of their family history. And that's why it's very complex. That's why you have that cloud overhead. It's like, hey, we got to reel this in. We got to, otherwise, because if that keeps festering and growing and growing and growing over a period of time, it's going to get so big, it's going to be hard to wrap people's heads around it and to resolve it and find a solution that or answer to the question that everybody can agree on. Again, it doesn't matter if a large majority disagrees with going to court. It doesn't matter. Come to court and have your voices heard. Make your argument. But the risk of losing the land. But again, if it goes uncontested, it goes uncontested. Just like the land developer. And there's examples out there. There's issues out there where people have lost their land because they didn't contest it. They didn't show up to court. Either because they didn't want to get involved, either because of protest, out of protest. Anyway, so I think I want to wrap this up a little bit, but I want to touch on one other thing from his website. It talks about fraud. Because it answers the question, when would I possibly encounter a suit to acquire a title? Right? It gives some examples here. Error in recording fraud. And fraud is a false representation of a matter of fact, whether by words or by conduct, by false or misleading allegations, or by concealment of what should have been disclosed, that deceives and is intended to deceive another so that the individual will act upon it to her or his legal injury. Cases in which a property has been fraudulently recorded, such as a forged deed. Again, as I mentioned, there was fraud and forgery. Right? In 1983, this is documented evidence. In 1983, one of the individuals, who may or may not have a claim to his property, or who was a defendant in this case. At the time they weren't, but 1983 signed a sales contract saying that they bought land from one of the original owners of the property. The name's on the deed, and again, this dating back to 1872 to 1898. So one of the original owners whose name was on the deed to own this property allegedly was still alive in 1983 and sold this partial land or land to this person. Fraud, forgery. How was the original owner, one of the original owners, still alive in 1983, and two, how did his signature get on the sales contract? Again, fraud and forgery. So cause injury to the rightful heirs, owners of the property, regardless of who this person is, regardless of what side of the tree this person falls on, committed fraud and forgery. And that's the kind of activity that's going on. So again, members of my family had the right to bring this before the court because they were being sued for their alleged transactions, indiscretions against the estate for using that money. But yet, on one hand, you got an individual who committed fraud and forgery. So we brought this before the court, and it was an inducing court. It was part of the summons complaint. Again, that's for another story, another video. But it's there, right here. It says from this website, Watts Law Firm PA out of Somerville, South Carolina. This is their website. It talks about why would you bring, or what would you encounter, right? So when a company or a law firm is paying somebody to do a title extract on a property to research whether or not a piece of property has a clear title, that there's no lien against the property, that's not going to be foreclosed, that the person that currently owns the property owns it outright, there's no heir issues, ownership issues, that's free and clear. That's what it means, clearing a title. Right? Discovered fraud. All these issues popped up, and the law firm out of Columbia that initially did it, put all this in a letter, advising their clients, as to how to resolve this issue by following the list, tenants, acquiring a title, doing a survey, updating this, updating that, doing this. It's all right here. It's all right here. And this is me doing my research. This is me trying to understand what's going on. Again, documentation. Everything that was given to me was discovered from title extract. Documentation that's up there at the deed office or on the library, online, news articles. I mean, I could read all this stuff to you, but it's important that everybody understands what needs to be done. Laws are in the book for a reason. And granted, the verdict, the judgment may not be to your liking, to everybody's liking, but these judges and lawyers, they get paid big bucks to do what they do. And either we can abide by it or not abide by it. We can agree or not disagree. We can agree or disagree, but but I think that's when I add that to the storyline. There's more to it too. I can talk about. I've been talking for like 45 minutes now. Maybe got to add a little bit more. So in 2017, again, there were a series of meetings being had in 2016 while I was on my terminal leave from the Air Force, retired from the Air Force. So let's fast forward to January 2017. In January 2017, I might even have the letter that was published. I think it was in January 2017. No, I don't have it. Well, there was notification that there was going to be a meeting in January of 2017. I believe it was January 20th or 21st. I can't remember what day it was. When I was going out of town. I was going out of the country on vacation. So I wasn't going to be attending that meeting. But there was a meeting held, and then there was another meeting called for the 4th of February 2017, and I showed up to that meeting. I showed up, and I put this in the summons complaint. So I'm kind of like bouncing between the two, but I was there. Again, this is before this summons complaint was filed in court and before the defendants were served. So this still plays to this video, the purpose of this video. So on February 4th of 2017, I showed up to the meeting along with my grandmother and one of my cousins. My cousin, her grandbaby, her grandchild, as I'm her grandchild too. So both of us showed up, and one of her children, her son, our uncle, and there was other cousins of ours that were present. So had this meeting, and so I'm sitting there, or actually I'm standing there, we're in the back observing what's going on, and not everybody was present. Again, prime example of calling a meeting and the key people who were supposed to be managing this property, held officer position, was not there for one. And I addressed this in the summons complaint. We're not there. Everybody was not notified. So basically conducting a meeting without a quorum, without a large majority or a certain number of people to be present at a meeting to make decisions. So, and I addressed it. I said, you can't have this meeting because the officers are not here. You don't have majority of the officers who are present, especially the president and the vice president are not present. For those that understand Robert's rules or bylaws or parliamentary procedure, business rules, as far as conducting meetings, well, understand that if you don't have the president and vice president, you really shouldn't be having no meetings unless it's been identified that another officer is going to carry on that meeting in their stead. But that didn't happen. So again, and then you have a small group of people, like 10 people, probably not even then, 10 people sitting in these meetings. Who are you? Why are y'all here? What's your role? What's going on? What's the topic of discussion? And the topic of discussion was about paying the taxes. for 2016 because this is now February of 2017. Taxes need to be paid. How are they going to do that? The bank account was frozen. It was controlled by the courts. And there was disagreements about how to get that bank account out of the hands of the court and give it back to the people. Well, you can't do that without a lawyer. You might be able to do it yourself, but you need a lawyer to do that. And no one's willing to fork over money to do that. Again, it's all in the meeting minutes. It's in the meeting minutes that there was disagreements about that. So fast forward to February 4th, 2017, I'm at this meeting. I'm just sitting here observing along with my grandmother and my cousin and my uncle and a few other cousins, just observing, trying to figure out what's going on. And I let it be known that, one, you can't have this meeting because not everybody was informed. You don't have a large majority. Not everybody was informed. And this goes against proper protocol. They didn't want to hear it. You know, people had attitudes and, okay, hey, I said my piece. You know, I said what I had to say. And talking about taxes and trying to vote and how we're going. I said, you can't vote. You don't have, the people are not here to know what's going on. You can't vote. And so, you know, I let them know that, well, let me ask you a question. Here's a question for you. How did the taxes get paid for 2015? No one knew. And again, this is in the meeting minutes. From 2016, the question came up is, does anyone know how the taxes for 2015 got paid? And I was part of that. Like, I wrote the $3,900 check to help pay the taxes. Now you have individuals living on a property that are not come out of pocket to help pay the taxes, but now they're asking everybody to come forward and help pay the taxes. So I asked the question. I told them that I'm responsible. Me and my family help pay those taxes. So y'all sitting here doing what y'all doing goes against proper protocol. And then again, I was questioning, well, why did you do that? Why did you? I said, because it needed to be done. Y'all not doing it. Y'all sitting here discussing on how to do it and you couldn't get it done. And still haven't got it done. Again, I was there. You can call it hearsay, call it whatever you want. I was there. It was introduced into someone's complaint. And they didn't challenge it. The defendants said they deny all, but they didn't provide the evidence to prove otherwise. That what was stated in someone's complaint was false, was not true. If it was, they were supposed to come to court and make their argument. Right? No, in February 4th, 2017. But there was another meeting that was called based on this letter that was mailed out, dated February 11th, 2017. So I assume that's the following Saturday. The following Saturday, 1 week after I showed up to this meeting on February 4th, this letter was mailed out. Or let's see, was that right? Yeah, I think it's about Friday or Saturday. And in his letter, it talks about having a meeting scheduled for February 18th of 2017. Now, I didn't receive this letter. It's not addressed to me, so I didn't know they're having a meeting on that day. But if I knew, I would have showed up. I definitely would have showed up. And I may have been out of the country at this time anyway. I might have been on a business trip. But needless to say that, again, another series of meetings, another meeting being called, not everybody being informed. You know, it shows the names of who were present, who were CC'd on this letter, calling them to come to a meeting. And nowhere on here is my grandmother's name, my mother's name. Again, being exclusive, not being inclusive. Everybody should have been informed, especially those that live in and around the property. Especially those that have a greater say as to what's going on should be informed. And there's a lot of people that are not on this, were not CC'd on this letter. That should have been CC'd. Again, so the summons complaint that I was part of to acquire the title was filed in April of 2017. So this is, March, April, 2 months, 4 months into the year. I filed it to acquire the title. and everybody had a right to come forward. Again, I had two cousins that contacted me early part of 2017. Those that lived in and around the property that are actually were plaintiffs, or some of our plaintiffs in a previous case, and defendants in the previous case were informed. Right? They were informed. They received some kind of notification either by word of mouth, by being served, by hearsay of the rumor mill. They were informed, whether officially or unofficially. They were informed, and I did my best I could to make sure that members of my family on both sides of the family tree, my grandmother's side and my grandfather's side, knew what was going on. And granted, I was not the spokesperson. I didn't try to be a spokesperson because I was playing my role. I was further down the family tree line that, again, advising my mother and her siblings as to what to do based on what the lawyers told us. Again, the means were there, and people not paying attention, or they step up and then they walk away. They step up and they step back because it's too much is going on. It's too hard. Again, from the 90s into the mid 2000s, prior to the first lawsuit, there was a lot of people. I'll say a lot of people. There was people that stepped up and stepped back, and didn't follow through. Well, I stepped up, and I've been following through since I've been in part of this. And all the backlash, all the negativity, or the, hostile comments, threats, is all coming from family members or others, and to be clear on this, I didn't break no rules or break no laws. If anyone has evidence that, I committed a crime, they should bring it forward. Let's clear evidence as who committed crimes, who provided misinformation, but it wasn't me. That's all I gotta say. So anyway, I've been talking for a while now. I think that hopefully I cleared up some of the questions that some of you might be had watching this video. I know it's been a long video, almost an hour now, but I needed to get out there. I needed to add this bit of information to basically add to the story and hit on the key facts of information. Because knowledge information is power, right? But it needs to be accurate. There's one thing I learned in the military. We need accurate, up-to-date information, concrete information, correct information. Because false information, wrong information causes so many problems. Again, it's part of it. It says forgery, right? Fraud. I'm sorry, not forgery, but fraud. If you suspect the error in recording or fraud, things you're going to discover during bringing collateral action to the courts. There's already issues. That's why you're going to clear the title, because one of the original owners are dead, and there's been a long period of time where things have been convoluted. It's hard to prove what's what and who said what, who did what, but if you have documentation to prove it, I mean, what you going to do? What are we going to do? Again, when it comes to family, some things may be in black and white, and some things may not be in black and white. There's that gray area, and feelings are going to get hurt. People are going to get hurt, but you got to do what's necessary. So people had opportunity to come forward. They didn't come forward. The courts made a ruling on it, and try to resolve it, try to fix it, and people not abiding by the rules, abiding by the laws, you mess around and you lose out. Being ignorant of the law does not give you the right to break the law, or not to participate, or not to understand, or not to get involved, or you can't go to court and say, well, I didn't know, and the judge or the jury is going to let you off. That's not how it works. But anyway, again, I've been talking for a long time. I'm going to wrap up this video. I appreciate those that stay with me and have watched the video this long, and watched my videos hopefully brings is giving you insight to the legal issues as well as the problem sets dealing with heir property, family on both sides, the legal side and the family side of the house. You know, being in the middle is not easy by any means. Trying to appease both sides of the family and try to do things right in accordance with the laws and rules. It can get the lines can be blurred, and we're not going to do everything that's what's best for everybody, but it should be what's best for the majority or what's best for the property by way of the rules and laws, by way of agreements. With that said, we'll wrap this up and close out this meeting. Again, thank you for watching. Please like, share, subscribe to my channel, share my channel, leave a comment below, good, bad, and different. I really appreciate it. Thank you. Take care. See you next video.
Okay, so thanks for watching the video. It was a longer video, but I think that the video basically gives credence to things I experienced. The additional information, additional conversation and information definitely expands upon my experiences and helps tells a story. Again, to control the narrative, to combat, if you will, the false narratives that were created to, again, attack my character, damage my reputation, create this animosity and division drama with family because of my involvement in trying to resolve the legal issues by starting with quite a title. So again, thanks for watching the video. Apologize if it was too long for you, but hopefully you watch it to the end, or you are able to come back later and watch the video. Definitely give you better insight to things I experienced, and yeah, just appreciate it. Thanks so much. See you in the next video. Take care.